With that, if council would please come on 116777, Joseph Wright versus Kansas Department of Revenue. Mr.
May it
Mullin?
please the court, Michael S. Holmes, second on behalf of the appellant and petitioner, Joseph Wright. If I can please reserve 5 minutes for rebuttal.
5 minutes is reserved.
Thank you, Your Honor. This is a DUI case, which is actually a licensing issue case, though, stemming from an argument made in regard to this court's recent decisions in State v. Neese and State v. Rice, declaring the refusal law, KSA 8-1025, as being unconstitutional. As the court is aware, the Kansas implied consent law requires that an individual be informed of the consequences under that refusal law, which has been declared to be unconstitutional, prior to requesting testing under the implied consent law. As a consequence, the question really before the court today is, what is the impact of advising of an individual of something that has now been declared to be unconstitutional and is an incorrect advisory of both their statutory and their constitutional rights? That brings us directly to the first question before the court, which is precisely that. What is the impact? As the court is aware, an individual, in this case...
Isn't the first question is, how do we get around Martin?
Right.
You said this is a DUI case, actually a driver's license suspension, and that's a big distinction under Martin, that you don't have the same rights in the civil driver's license suspension hearings that you do in the criminal case.
Correct, but we're not arguing here exclusionary rule. We're not arguing Fourth Amendment. We're not arguing any of the things that were prohibitive in Martin. What we're arguing instead is due process, fundamental fairness. What can the state do if the state, well, not even intentionally,
but wasn't that a due process violation in Martin when they stopped without having reasonable suspicion?
Not really. I mean, having argued these for years, yes, that has to be cloaked into due process issue, but it's really a Fourth Amendment issue. And then that's what the court was focused in Martin, is the legislature has chosen not to allow reasonable suspicion in Martin to be an issue that can be raised before the administrative hearing officer and before the district court. So they statutorily had excluded that from purview. That's entirely different than the poison pill that exists here, where the legislature has required mandatorily that an individual be advised of something that is not correct and be threatened with something that is not only coercive, as this court has found to be coercive, but intentionally coercive. That goes to the fundamental structure of the law itself and has nothing really to do with Martin.
So is that procedural or substantive due process?
It would be both. It would be procedural because obviously an individual is entitled to due process as a right of procedural matter. Part of that certainly has to be an individual then equally has to be properly advised of what their rights are. And if part of the statute incorrectly advises them of both their statutory and constitutional rights, that would at the very outset violate their procedural due process, which should then be able to be cured at any hearing as we have today. So the procedural due process really stems at the origination. The substantive due process should be self-apparent. You can't create a statutory scheme that is intended to coerce somebody and then use unlawful advisories to coerce them. This is entirely different than the original fundamental premise of the Kansas implied consent law, which was to lawfully coerce somebody. There is nothing unlawful if you tell an individual if they don't consent to a test that their driver's license will be suspended longer than it would be than if they consent and they fail it. That would be lawful coercion. It may affect criminal proceedings. We'll talk about that in the next case. But at least in this case, there's nothing wrong with the state doing that. What changes things drastically is when, as part of the mandatory statutory advisories, an individual is threatened or coerced with unlawful means. In this case, telling them it's a crime, telling them they have no right to refuse, all of which things are not true. That is unlawful coercion. It violates their fundamental rights. And that's really the question today, is if you have those unlawful, incorrect advisories incorporated as the mandatory requirement before requesting testing, what is the impact? Should the state still be allowed to suspend their driving privileges after they have incorrectly advised them of what their rights is? When the simple answer, at least from our perspective, certainly should be no. And that really, I know it seems overly simple, but that's really the question. It's fundamental fairness. And can the state be allowed, or should the state be allowed, to suspend an individual's driving privileges when that state incorrectly and improperly advises them of something in order to coerce them to do what they get them to do eventually anyway? And that's really the whole purpose of fundamental fairness under the Due Process Clause. Where the Court of Appeals ran astray, and we're going to hope that the Kansas Supreme Court, in our estimation, doesn't run astray, is arguing or bringing up things such as the exclusionary rule and good faith. The admissibility of the breath test or blood test has zero impact on this argument. It is irrelevant. An officer's acting and following the statute properly has zero impact on this argument.
Why is it irrelevant if we start with the premise that the DC 70 that was given accurately stated the statutory requirements as they existed at that time, and that the coercion that you're talking about deals with a issue where we have said you will not be able to use the results of the blood test because it was obtained coercively. But Martin tells us that's an issue that's set aside. So why does it change the impact of the license suspension proceeding? I mean, it's easy to make it sound like it's a non-Martin case, but when you get down to the nub of it, isn't it still just about whether or not they can use that information? And in the driver's license suspension area, they can. Therefore, why is the advisory not correct?
Because those are in two entirely different questions, really. The legislature, when it chose to deal with DUIs differently than every other crime, and chose to intentionally try to coerce people into acquiescing, not legally submitting, but acquiescing to testing, chose to venture off of the normal Fourth Amendment grid, okay? They're allowed to do that in a licensing case. This is what we're here for. They can coerce them. It doesn't matter, as in Martin, whether or not there's a reasonable suspicion violation. The exclusionary rule doesn't necessarily apply because it's a licensing case. But when you do that and you structure that scheme, you can't, as part of that scheme, threaten them with something that is not correct. You can't threaten them with a crime when they can't really, when that crime actually isn't a crime now, when it's been declared to be unconstitutional. So by incorporating in unconstitutionally coercive advisories as part of the scheme itself, you're not talking about something with Martin, which is whether or not an officer independently violated an individual's Fourth Amendment rights. You're talking about the structure of the law itself. And the structure of the law itself includes unconstitutional advisories. The state shouldn't be able to rely upon that unconstitutional structure to then suspend an individual's driving privileges. What we'll get into in the next case, but since you brought it up, the separate issue is, aside from that statutory construct that the legislature's chosen to create to help to coerce people into taking tests, what's the Fourth Amendment impact? And in Martin, this court said, well, we don't care about the Fourth Amendment because this is a licensing issue. Okay, fine. But the court should still certainly care about whether or not an individual is being properly advised of their rights under the Constitution and their statute, because the legislature's chosen and taken it upon themselves to require those advisories be given. In the criminal context, that's different. In the criminal context, we don't necessarily care directly whether or not the state's going to take their license or they're not going to take their license. It's a much more fundamental, easier question actually in the Fourth Amendment perspective or a criminal case. Can the state prove voluntary consent free of duress or coercion? I'm not going to get into that now. We can get into the next case. But that's an entirely separate issue. And Martin said, we don't want to deal with that when it's just a driver's license suspension. Fine. That does not negate our argument here today that regardless of the Fourth Amendment issues, even if you don't touch them, even if the officer acted in perfectly good faith, The statutory construct itself is unconstitutional because you're telling somebody to get them to take a test. You're threatening them with something that isn't even a crime. You are improperly advising them. The legislature chose to do that. That's what renders it inconstitutional.
Counsel, how is that not just a sophisticated argument for the exclusion of this evidence? I guess I'm still confused when you said you're not making an argument about the admissibility of the evidence.
Exclusionary rule only applies to the admissibility of evidence in criminal cases. Whether or not the test results are admissible or not, whether this is a refusal or a failure, what happened, whether my client is guilty or innocent, is irrelevant. The question is the statutory construct itself unconstitutional?
You're just saying illegal coercion equals an absolute bar from the state proceeding.
If the question is fundamental fairness, if the legislature creates its own statute and as part of that statute incorrectly tells somebody what their constitutional rights are, yes.
Why does it matter whether it's a statute or just a law enforcement officer illegally coercing someone in the field?
If it's a law enforcement officer illegally coercing somebody and it's not part of the statute, then you can still probably suspend their driver's license.
Why wouldn't the due process violation that you allege be identical?
It wouldn't be identical because it's not part of the statutory
But that's what I'm asking. Why does the individual who is illegally coerced in your scenario care what the source of the coercion is? It's like, I don't care whether it's in a statute or it's a bad actor out in the field.
My clients never care. They just want to win. But we who dabble in the area of the law and of jurisprudence have to care because those distinctions are not without a difference.
Why would it be different if instead, as my colleague suggests, the officer just says, submit to this test or we're going to put your child into involuntary servitude? Wouldn't that be pretty coercive?
That would be extremely coercive, but again, the Kansas implied consent law is coercive. Okay? And so the Kansas, and actually we could raise that ironically, because then the officer would not have provided the statutorily required warnings. He would have given his own, and that would be grounds for me to represent my client and say you can't take my client's driving privileges because the officer went off book and did something that the statute didn't provide for. And so all of these things.
Well, I understood you earlier to say, well, there's a big distinction between lawful coercion and unlawful coercion. So why wasn't the simple answer to my colleague's question that that's unlawful coercion?
Well, it is, but I guess I was addressing the Martin issue and the exclusionary rule issue and tying it backwards. If it was just straight, we don't care where the unlawful coercion comes from, I agree with that completely. If you're unlawfully coercing somebody, you can't rely upon that to take their driving privileges.
Let me, you're out of time here. Let me ask you real quickly. You seem to say that the failure to give the mandatory warnings results in a dismissal of the driver's license proceeding, correct?
Correct.
And the basis for that is?
It's in my brief. I'm sorry to go through it. It's both statutory in multiple different areas. The officer must certify that they gave the required advisors, both orally and in writing. They must submit a written form.
And the KDR has to review it and all of that, but,
right.
But nowhere does it say that dismissal, does it?
Other than precedent, and that has been interpreted that way by this court and Kansas appellate courts since long before I began practicing. I'm out of time, so unless there are any other questions.
Counsel?
May it please the court, Ashley Iverson on behalf of the Kansas Department of Revenue. The ultimate question here revolves around the fact that Mr. Wright was arrested prior to Rice and Neese, and those decisions are the decisions that rendered 8-1025, the criminal refusal law, as unconstitutional. If I may, the material facts are not in dispute. Mr. Wright was arrested on February 4th, 2016. This is 22 days before the Rice and Neese opinions. The highway patrol trooper Walker provided him those advisories Mr. Holland mentioned, and Mr. Wright consented to a breath test. In addition to that, Mr. Wright has no prior occurrences, And that's key here because he was not even subject to those criminal sanctions condemned in this court regarding refusals to a requested test. In regard to the procedural due process violation argument by Mr. Holland, I would submit to this court that there is notice to Mr. Wright. He had an opportunity to be heard through the administrative process with KDOR. And ultimately, in this state and in this country, driving is considered a privilege and not a right. This law is a remedial law, which is to be liberally construed to promote the health, safety, and welfare for the public. In addition to that, I know Mr. Holland contends that there's no Fourth Amendment arguments, but I see those in the briefs, and my response to that would be reasonable grounds was waived in this case. This is a search incident to lawful arrest, and under this court's reasoning in Rice-Neast and the U.S. Supreme Court's reasoning in Birchfield, this breath test was properly requested under this valid search. There was much discussion in briefs about blood tests, but this was not.
How was the officer going to accomplish the search incident to arrest without the consent? A blood test, you can get your buddies and hold them down and withdraw the blood, but how do you get deep lung air from a non-consenting driver?
You can't. They have the absolute right to refuse. There are collateral.
Well, but you say, well, they had a right for search incident to arrest, but that's a right without a remedy. There's no way they can accomplish or effect a breath test incident to arrest without consent, is there?
That's correct. Physically, how could you make someone submit to a breath test?
This is an academic argument as to whether a search incident to arrest applies when in effect it can't apply because it can't be done.
I would admit to that, Your Honor, absolutely.
So are you conceding that there's no material difference between legal consent and physical cooperation?
No, that's not where I'm going in this argument, Your Honor. The reason I brought up the search incident to a lawful arrest is purely because this wasn't a refusal, this was a failure. And Mr. Holland's contentions, I understand he's not arguing that any results should be suppressed because the exclusionary rule doesn't apply to these proceedings. But ultimately, I would submit to this court that the officer, if we're going to go down that road, acted in good faith on existing law at the time of this arrest. Furthermore,
Counselor,
yes.
Let me clarify since you're a little break here. You started out by saying that Mr. Wright was arrested 22 days before Rice-Neast, but you would agree that his case was pending on appeal, or pending, and so you're not saying that Rice-Neast do not apply here, are you?
I don't see anything in Rice-Neast to suggest retroactive application, and those opinions, that's precedent that there needs to be specific language that we indicate this to be retroactively applied. That being said, the day of Rice-Neast, the Attorney General's office revised these advisories to comply with this court's condemnation of those unconstitutional provisions, and KDOR distributed those forms that were revised by the AG's office. They acted immediately and did not wait for the legislature so that they would not.
Counsel, there's no need for retroactive application if a case is still pending at the time an appellate decision comes down, is there? You're confusing retroactivity, for example, a later passed statute, that sort of thing. If a case is pending, either in the district court or on appeal, and an appellate decision comes down, that appellate decision applies to the case, doesn't it?
Your Honor, I think the practical effect in this case is if we were to deem DUIs that were conducted, these investigations, based on this advisory, which was created in July of 2013 and is the same advisory used for Mr. Wright before the revised versions, I don't see how law enforcement, let alone anyone, could know that the court would rule.
That's a different argument.
Yes.
That's your good faith argument, isn't it? It's not that they don't apply, it's that no officer would have known they were coming. And that's
Yes,
a
Your
good faith argument, right?
Yes, Your Honor.
Okay, thanks.
Is there an inherent authority for KDR to suspend driver's licenses?
Inherent authority?
Isn't it all statutory?
Yes, Your Honor.
And if the statutory scheme is unconstitutional, then what authority did the KDR have to suspend? And
Based on the
we're going back to Cody, way back on Gould, it said that if a statute is unconstitutional on its face, which I believe we said, then it's null and void. And if you have part of the scheme that's null and void, by what authority do they go ahead and proceed, even if they thought it was legal prior? You understand my question?
Yes, Your Honor, I do. There is a severability clause in 8-1007 that states, if any clause, paragraph, or subsection of this act is to be held invalid or unconstitutional, it shall be conclusively presumed that the legislation would have enacted the remainder of this act without such unconstitutional or invalid provisions. Ultimately,
So you're saying that the warnings weren't necessary constitutionally?
not at all, Your Honor. In Rice and Neese, this court held that one provision of the implied consent law was unconstitutional, and Revenue and the AG's office acted immediately, and so that they would not improperly advise drivers the day this court found that to be unconstitutional. That severability clause, I mentioned that just because of situations like that where the intent is there to promulgate constitutional laws in this state, and that's presumed as such.
And I think then do I understand you to say then if you sever the part about the being potentially committing a crime if you don't consent, because that didn't apply to this defendant, we can sever and know that it doesn't make any difference to his consent? Is that the argument you are making?
In regard to the severability clause, I'm making that argument for any driver. If that provision is taken out, the rest of the statute is still constitutional. For Mr. Wright in particular, and for other individuals where this would be their first occurrence, 8-1025 that criminalizes a refusal if you've had a prior occurrence doesn't even apply to him. So in regard to a substantive due process violation, it's not even as applied to him, let alone I would submit to this court facially unconstitutional as a whole. Ultimately, I think the key here is just concentrating on the time of this arrest, in addition to this is a remedial law. And finally, the Court of Appeals, I understand Mr. Holland indicating that they perhaps misinterpreted his arguments, but this Court of Appeals have been consistent and persuasive regarding this exact same issue. And I think we would have been remiss at KDOR or the AG's office to ignore the Supreme Court's ruling in Rice-Neese, and we acted immediately. And for those, yes, Your Honor.
Yeah. Do you agree that with Mr. Holland that the DC 70 as written then is unconstitutional, that it violates due process, that it is illegally designed to coerce?
I would concede that paragraph 4, which is the criminalization of the refusal, that's undisputed that the Supreme Court held that, Your Honor. But that's for paragraph 4.
So it doesn't. So you're. What do you? So you point out that it is. So what is it that you're? There's an exception to the due process violation because why?
Because that particular provision that was condemned by this court did not even apply to Mr. Wright. And there is case law to suggest that people...
And how does he know that it didn't apply to him? It was read to him, wasn't it?
Right, Your Honor. Yes, it was.
And he's supposed to understand that he didn't have a prior, so it doesn't apply. Is that what you're suggesting?
I would submit to this court that someone, even if they don't... I would hope that someone would know if they've had a prior DUI. I can't speak for every driver, but I think that's a responsibility that isn't too far-reaching to ask of someone.
Is your argument that the breath test was obtained in this case did not violate the Fourth Amendment, or is it that it doesn't matter that it violated the Fourth Amendment because we have the Martin case, which says we don't exclude evidence and we have a good faith exception? Or are you trying to make both arguments? I'm not tracking between those two categories.
Yes, Your Honor. It's not that I'm trying to have my cake and eat it too, but I am trying to respond to the alternative arguments that I believe were briefed by Mr. Holland. And I do submit to this court that if we do go down the road of a Fourth Amendment violation, this was a search incident to a lawful arrest, and it was a breath test failure. I would also note that Martin is good law still, and that the exclusionary rule does not apply to these proceedings. But even if it did in this case, the good faith exception would apply because the officer was acting under an advisory that was constitutional at the time. I believe State v. Kramer, a Court of Appeals decision, has some language regarding the good faith exception, and that petition was denied before this court. I want to make the distinction that this is civil, and as Mr. Holland mentioned, a criminal case is next. And that's not meant to say it in a flippant manner that, oh, it's just a civil matter, but there is a difference, and that distinction is important.
Would the distinction be as important? Let's just say the law was really flawed and it was discriminatory. It treated a different class of citizens differently than others. Would Martin still apply in that situation? How far in your mind does Martin go?
I don't think it goes that far, Your Honor. I can't imagine that the legislature would...
Well, let's just say this, for instance, that occurs.
Hypothetically, laws are presumed constitutional, and if they fly in the face of complete lack of indications for someone's rights, I think that's an argument for a different day, Your Honor, and not applicable to the facts here, although I do understand the hypothetical. But ultimately, we're not hanging our hat on Martin and acting like anything can happen. You know, people's rights don't matter in these proceedings. That's not the case at all. There is a procedure, there's an administrative process, there's an appellate process. We're here today before the Supreme Court. Folks have an opportunity to contest these interactions and these investigations.
Do you agree with opposing counsel's statement that the failure to give the warnings mandates a dismissal of the driver's license suspension proceedings?
The standard is substantial compliance as long as the essentials of the statute are given to the individual that they are indeed investigating. And that standard has been law since Barnhart, various case law, and that remains the standard to today. And I would submit to this court that there was substantial compliance.
If there is not substantial compliance, then dismissal is mandated.
Right, but not strict compliance. Substantial compliance is the standard.
Other questions? Thank you, counsel.
Thank you, Your Honor.
Mr. Holland, you reserve 5 minutes.
Thank you, Your Honor. Just to follow up on what was just discussed with the court, it actually points out our argument. If failure to give substantial compliance of the mandatorily required advisories necessitates the administrative action being dismissed, then why wouldn't the inclusion of constitutionally defective advisories also require dismissal of the administrative action? And the simple answer is it would.
In other words, an advisory that's unconstitutional is not substantial compliance with that statute?
Well, it would even be worse because then it means that the statute itself is unlawfully advising the client or the individual. And that kind of summarizes our argument to a T. This is a statutory construct that's licensing and allows license suspension to be done after procedural due process, which requires substantial compliance with those advisories. If those advisories, in and of themselves, are unconstitutional and incorrect, the outcome is determinative. That means you can't suspend their driving privileges. It just really is that simple. Another thing that came up during examination is this argument regarding, well, Neese and Rice hadn't come out yet. Well, if somebody had been charged with violating the refusal law, KSA 8-1025, and 22 days later, Neeson Rice came out, they still wouldn't be subject to the criminal sanctions under KSA 8-1025 because that law's been declared unconstitutional. This is a very similar circumstance to that. The advisories that were given 22 days earlier may not have been, at least by written law, although these arguments already existed, may not have been already declared to be unconstitutional, but they ultimately were. And so since those advisories have been declared to be ultimately unconstitutional, suspending an individual's driving privileges after being given those unconstitutional advisories also should no longer be allowed, just as you couldn't prosecute somebody under the refusal law now.
Counsel, I understand you don't rely on the good faith exception. You don't think that applies. But if we were to get there, do you think that the officers had a good faith basis, or do you think they should have known that this was unconstitutional?
Well, that's kind of like asking the difference between did they consent or did they lawfully consent when we're arguing about consent. Okay, did the officer have malice or know what they were doing was wrong? No. But good faith as a legal construct it goes further than that. It requires some sort of either judicial review or some sort of basis for admissibility. Did we argue the officers were acting maliciously or they should have known the law was unconstitutional? Of course not. But that doesn't matter. The law itself was unconstitutional.
Let me just rephrase the question.
Yeah.
If we get to the good faith exception, is your position that you concede it applies, or you think that it doesn't? You think that it wouldn't apply on its own, on its face?
And again, we're not skipping ahead one case to another. Good faith doesn't apply here because good faith doesn't allow for the admissibility of this evidence.
We understand that's your argument, but just hypothetically, if we are looking at it here, does the behavior here qualify for the good faith exception? It's a reasonable officer, not subjective belief.
Okay, it's just as a pure, did the officer do anything, wrong? No.
Not as the law existed at the time.
Correct. Again, I get real caught up in arguing what good faith really is and isn't, and that'll probably be more clear in the next argument, so I'm not trying to be difficult. But no, the officer was following the law as trained, did nothing wrong. The problem was the law itself was defective.
Yeah.
And this wasn't an issue that came up 22 days after your client was arrested.
No.
That issue had been out there and litigated, and it just got up to the Supreme Court of the state of Kansas, so it was in the pipeline. And so law enforcement and law enforcement trainers should have known that there was a challenge to unlawful coercion, right? I mean, it's not like if you're going to have good faith, you can't turn a blind eye either.
And to go one step deeper, the legislature should have known. When the legislature passed a law criminalizing an individual's ability to consent or to refuse to consent, they knew they were stepping off of the well-trod ground of search incident to arrest and established Fourth Amendment law. The legislature knew they were taking a risk. It blew up in their face, and because of that, they have literally hundreds of cases where the evidence should not be admissible because they voyaged away from what had already been approved by this court and other courts as the foundation for the implied consent law. And they went away from search incident to arrest, and they created a statute that is relying upon voluntary consent, but inside of that own statute, they intentionally coerce people. You can't have voluntary consent and coerce them all in the same statutory scheme. That is, by definition, unconstitutional and illogical.
If 8-10-25 doesn't apply to your client, however, how is it coercive to him? And as applied to him, how is this unconstitutional?
It's not so much whether or not technically it would apply or not. It has to do with that being presented to them. And if you've ever read through that and you know the circumstances, you've been arrested, you've got an officer who puts something in front of your face and reads you all this legal mumbo jumbo, all you hear is if you refuse, you can be charged with a crime and you don't have constitutional right to refuse. That's what sticks out in your head. It's like, what? Okay, fine, I guess I'll take the test.
Reggie? The inapplicability then has no bearing on this issue, just because it was structurally defective?
If it was a strict, can they charge my client with refusal? No, technically yes. But as far as are we dealing with what were they provided and whether or not that was unconstitutionally coercive? No, whether or not that directly applies to my client now knowing what's in his driving record, not most of my clients don't know what's in their driving record, and they don't know what counts as a prior and what doesn't count as a prior. And so, no, if you read those advisories, no, it doesn't make any. It's a distinction without a difference. And I see I'm out of time. If there are other questions,
Any other questions?
thank you.
Thank you to both counsel. The court will take this matter under advisement.